Well, today, the biggest news is Donald Trump's trial. The closing arguments were made both by the prosecution and the defense in the first criminal trial, I should say, of a sitting, well, she's not sitting, a former U.S. president who is seeking to be the president of the United States. For the first time, we saw Donald Trump's children, minus Ivanka and minus his young son, Barron, join him in the courtroom with their spouses to show support for the former president. The arguments went late into the night. The arguments were, at times, very heated. The defense lawyer oftentimes raising his voice, particularly when he was talking about Michael Cohen, a star witness for the prosecution, especially as he was calling Michael Cohen a liar. Much of the defense's argument centered on Michael Cohen and the fact that he lacks credibility and that the jurors should not believe Cohen. And if they don't believe Cohen, so the defense argument goes, they should find that Donald Trump is not guilty of the charges. Now, the prosecution says that there's ample evidence. There's notes that were taken. There's text messages, there are emails, there are business records and other documents that clearly demonstrate that Trump was not paying Michael Cohen for legal fees, but rather was reimbursing him for the money he paid out to Stormy Daniels. Well, of course, my experts are here, veteran prosecutor Bobby Grace and veteran defense attorney Mansfield Collins, because I want to get their take on what we know. Of course, there are no cameras inside that courtroom, but we've gotten lots of reporting from reporters who've been sitting in. And based on what they've been able to read and hear from some of those folks who were inside the courtroom, what do they make of the job that was done by both the prosecution and the defense? So these are two lawyers that have seen a lot of courtroom trials. They've seen a lot of action inside a courtroom. So they know when a lawyer is making a good argument. They know when a lawyer is connecting with jurors, and they can pretty much predict what jurors are likely to do based on the evidence that's been presented at trial. So I am super excited to sit down with Bobby and Mansfield to get their take on the performances. Lawyers always like to rate each other on each other's performances, because a lot of what we do as lawyers is storytelling. Our job is to persuade you, is to take difficult facts and reduce them down to a memorable story, because we know people don't remember, facts and dates and numbers, all that kind of goes out the window, but people can relate to a good story. And so I want to ask Bobby and Mansfield, who was the better storyteller? And what do they predict will happen in light of this evidence? And of course, one big question everyone is thinking about is what happens if our former U.S. president, who's running to be president, is indeed convicted? Will he be remanded? That means, will handcuffs be put on him and he's whisked away to a jail cell? Will he be ordered to come back and show up for a sentencing hearing? What is the likely sentence if he is convicted? And what does all of this mean for the November election? Well, those are questions that you are asking, and we have all the answers right here on Areva Martin in Real Time. So when we come forward, Bobby Grace and Mansfield Collins, we are going to take you inside that courtroom and give you everything you need to know about the trial and what is likely to happen. You're going to feel like you went to law school after you listen to today's show. Bobby and Mansfield, both, thank you so much for joining me. I know you've been reading what the papers are saying and perhaps listening to what some of the pundits have been saying. We don't have cameras inside those courtrooms, so we're having to rely on those folks that were in and the reporting that they've done. But let's start by rating the performances of both of the lawyers. I'll start with you, Bobby. What do you make of the prosecution's defense argument?
Good afternoon, Areva.
Sorry, the prosecution's closing argument. I'm sorry.
Prosecution's closing argument. Well, they went over a little bit over 4 hours. Apparently, it was a very protracted prosecution summation. New York is a little bit different. In California, the prosecution goes first, then the defense, and then the prosecution gets a second bite at the apple. New York does it differently. The defense goes first, and then the prosecution goes. So it does make sense to me that the prosecutor would go longer then the defense, which went over 3 hours early in the morning. Apparently, from all reports, the prosecution did an excellent job. They summarized the case. They deflected. The main argument of the defense was that Cohen was a liar, and basically said kind of what prosecutors do in most cases, say, if you're dealing with the devil, then you have to take what the devil gives. And in this case, Donald Trump hired um, Michael Cohen. And so Donald Trump knew he was a liar, and he hired Michael Cohen because he was a liar. And ultimately, Cohen was forced to tell the truth because he was facing jail time. And basically, that happens in a lot of prosecution cases where you're dealing with individuals who are testifying based on a plea agreement or some sort of thing like that. Doesn't mean that they're necessarily lying. And I think that the prosecution did an excellent job of pointing out that their case doesn't stand alone with respect to Cohen. They pointed to tapes, they pointed to physical evidence, they pointed to critical conversations with key witnesses like David Pecker, who I think is a central figure here that not only talks about this whole catch and kill strategy, but the fact that ultimately he wasn't willing to pay the last time that Trump was wanting to catch and kill a case, which we know was Stormy Daniels. And he was the one who advised Michael Cohen how to proceed with respect to that. So I think all in all, the prosecution did an excellent job in terms of summarizing the evidence and calling the jury to use their own common sense to determine that, in fact, the only reason why Trump would have done this was because of the election. He didn't want the facts to get out, and he had the perfect fixer in Michael Cohen in order to take care of it.
All right. I think you're right. All those great points. And there's so much evidence, obviously, not just Michael Cohen. There's an overwhelming amount of evidence that was presented by the prosecution. Let me ask you, Mansfield, what do you make of the defense argument, particularly this one statement made by the lead lawyer for Trump? He said, every campaign in this country is a conspiracy. Hmm.
I just don't know if any criminal defense attorney could have done any more than what this criminal defense attorney did. He put all of his eggs in one basket. He blamed Cohen, and he basically told the jury he's lied 1,000 times. So it defies belief that now all of a sudden he's telling the truth. But jurors sort of understand that people do that. We have experiences with people that have a reputation for lying, but sometimes we understand that they are absolutely telling the truth. And in this case, I think the prosecution has the edge on the criminal defense. It's the jury will not just look at the evidence in front of the court today and over the past several weeks, but even though they are told to, keep an open mind, they aren't told to keep a closed mind with.
I think we're having some technical issues with Mansfield. Let's try to get his audio worked out. While we do that, Bobby, let me ask you this. The defense made a huge uh, error, and I don't even think it was an error, it was an intentional statement. They made the statement about Donald Trump going to jail, and the judge was livid because there's no evidence here that anybody's going to jail. What do you make of that? I'm going to call it slip of the tongue by Trump's defense team.
Well, it wasn't slip of the tongue, Areva. It was clearly calculated to impress upon jurors who have a mindset that Trump could possibly go to jail and would be squeamish about returning a guilty verdict if they thought that this particular judge would sentence Trump to jail. We know that because of past statistics here, that it's unlikely that a judge would jail Trump solely on this. Now, we do know that the judge was upset with Trump with respect to his, continual violation of gag orders. So there's a slim possibility that he could be jailed. If he is jailed, it won't be for long, because Trump being in jail causes so many problems that I don't think the criminal justice system could handle Trump being in jail, for certainly not for a long time. But this defense attorney played upon that fear to try to have a chilling effect on the jurors, that they wouldn't come back with a jury verdict of guilt, just so they could avoid the possibility of being the jury that sent Donald Trump to jail.
Yeah, that could obviously backfire on the Trump team, Mansfield. There may be some folks saying, hey, I want to be that person that sends a former president to jail. That might get me a book deal, might get me a lot of fame and notoriety. But Mansfield, you said this defense team placed all of its eggs in one basket, and that was the Michael Cohen is the greatest liar of all times. Tried to play on that term goat into gloat. Was there a different strategy? Could there have been another strategy based on the evidence that was presented? Because I do feel like, Bobby, that's a big risk, because you can throw Michael Cohen out and there was still lots of other evidence. Do you think the defense should have spent more time talking about that other evidence and not just assuming that this whole case was just about Michael Cohen?
So the problem when you're defending someone like Mr. Trump, who has a lot of baggage, it's hard to say that you can put on a defense and have character witnesses. In a criminal trial, you can ask character witnesses to come and testify for your client as attesting to his good character. Well, I think we all sort of, take a pause and say, wait a minute, what could someone say about Mr. Trump and his good character? And then you look at the witnesses. He only called 2 witnesses. He called an attorney that was again, a criminal defense attorney sometimes do not control their witnesses. And in most situations, whenever I've had an attorney testify in a deposition or otherwise, those are the worst individuals to try to control what may come out of their mouths. And the attorney that they called in Trump's defense made a big mistake. He was arrogant. He upset the judge. No doubt he upset the jury. Jurors are looking in any kind of trial, civil or criminal. They're sort of looking at the judge to take cues as to, do you think this guy is telling the truth, or are you concerned about this? And they build a relationship with the judge in every trial. And when that attorney that was called by the defense to testify on Trump's behalf attacked the judge and showed arrogance, I mean, in a sense, it was the same kind of behavior that we're used to seeing Mr. Trump engage in. And so I think that backfired. Now, could they have called a financial person to deal with the financial documents that were used to show that this money was spent this particular way? Could they bring in their person in charge of finance? Well, he's in prison for perjury. So this was an entirely impossible situation for the defense. Now, lastly, could they have taken the risk?
So what about a lawyer? Could they have brought in a lawyer that either was general counsel for the corporation or maybe was outside counsel to talk about this is assuming that these facts existed, that maybe they review the services provided by Michael Cohen and they did constitute legal services, or something to give more credibility to this argument that these were legitimate legal services?
I'm sure they thought about that. And I'm sure they decided we can't get an attorney who is judged by a much higher standard than the average lay witness. We cannot get an attorney to walk the plank for Donald Trump, because once he starts walking that plank, then you're open to cross-examination. And then who knows what kind of Pandora's box is opened. And who knows if you inadvertently open a door that the criminal defense wanted to keep shut. So this was just a terrible situation for a criminal defense attorney to handle. And also there was some criticism about the criminal defense attorney in that he used to be a prosecutor. No slight on you, Bobby. You gave a good introduction, but he was a prosecutor and didn't do apparently a lot of criminal defense work and not a lot of cross-examination. Well, that's really not true. Prosecutors do a lot of cross-examination, but they criticized this particular criminal defense attorney performance and said basically he didn't muster up to the task of doing a good cross-examination on the prosecution's witnesses. And then you had a client who had press conferences every day inside the courthouse. Please explain to me somewhere during this show, Areva, have you ever seen permission granted to any defendant to have a press conference in the lobby of a courthouse?
No, except this one who the lawyers, a lot of the criticism of the attorney is not that he's not a qualified attorney, but that he was playing to an audience oftentimes of one and was doing things to push the envelope and, you know, get the ire of the judge, not like he would do that in a normal case that he would be involved in, but because when you represent Donald Trump, you have to do that. You have to go outside the bounds of, you know, which we usually work in as lawyers. You have to do things like Bobby said, mention prison time when you know that that's impermissible in a closing argument, but you do it because you know it's going to, you know, get the excitement of your one client. And Trump is notorious for saying his lawyers are too soft, they're too weak. And, you know, a lot of the yelling apparently that Trump's attorney was doing was, again, to try to impress Trump because they associate yelling with somehow being strong or, you know, somehow being, I guess, an alpha man. So the louder you are, the more, you know, the tougher you are. So I'm not giving excuses for this lawyer, but we can understand the predicament, as you said, Mansfield, that he was in. You got a lawyer, you got a client that's talking. You won't shut up, won't listen to anyone. So it's a very challenging, but obviously he's getting paid a lot of money. Big boy. He knew what he was doing when he took the case. He knew how Trump treated all of his other lawyers. So we don't need to feel sorry for him. But I do question whether the closing argument, and maybe both of you agree there wasn't a lot of room for him, a lot of places for him to go other than to try to beat the Michael Cohen. And maybe if you hate Michael Cohen enough, maybe you'll hate the prosecution. Bobby, you think that's where they were going? Like maybe if we can convince them that this prosecutor brought you this lawyer, this lying lawyer into this courtroom, and you should punish the prosecutor for even, you know, having the nerve to bring Michael Cohen in and suggest that he is someone that should be believed. Think about that, Bobby. When we come forward, I want to get your take on what might be the strategy behind the defense just really, really hammering the credibility of Michael Cohen. Bobby, talk to us about what's going to happen as the judge reads those jury instructions, and particularly as he talks about the burden of proof and what beyond reasonable doubt means. That's one of those legal terms we hear a lot on Law and Order and other courtroom shows. But what does it mean in real life when juries go to the deliberation room and they've got to figure out what beyond reasonable doubt means?
Thanks, Areva. Reasonable doubt is what we would call not a mere possible doubt. You have to have what is known as an abiding conviction in your mind that the defendant is guilty of the evidence. What does that mean? Well, we know what it doesn't mean. You can't come in as a defense attorney or prosecutor and say that reasonable doubt is 90% or 80%. You cannot, by law, define it by percentages. We know that it's not a civil standard. So the civil standard may be 50% plus one. And so you can do that on the civil side. You can't do that on the criminal side. I like to tell jurors that if you feel that you do have that abiding sense, then you know that you've gotten to that place that is the land of reasonable doubt. And as we know, defense attorneys try to pick that apart and they want to focus in on one or two jurors that have the idea that possibly the prosecution didn't make their case beyond a reasonable doubt. And I think that's what the defense was trying to do here, Areva. They're trying to pick off one or two jurors that will not agree that the prosecutors met their burden and hang this jury or force the judge to declare what is known as a mistrial in legal terms, but in lay people, we call it hanging a jury.
Mansfield, two lawyers on this jury, and the defense attorney said, look, come back with a quick verdict. Like, this is a no-brainer. You should be able to go back to the deliberation room, and after one round of voting, you should come back not guilty. Tell us, traditionally, when juries are out for a longer period versus a shorter period, what does that typically mean? Is that good news for the prosecution, or is that typically good news for the defense?
If the jury is out for a longer period of time, that's good news for the defense. If the jury comes back in one day or half a day or in a day and a half, that would be good news for the prosecution. And so if the jury comes back in between 2 days and 4 days, then nobody really knows what that jury verdict is going to be. No one really knows. And having two attorneys on the jury, in the beginning, I wondered how two attorneys actually got selected to this jury. They come from firms. They have a lot of legal colleagues. We talk a lot as attorneys. And so I really question why the defense didn't try to get them removed from the jury. But in retrospect, the defense's theory has always been confusion, place all the odds, place all the evidence against Michael Cohen, and reasonable doubt. Therefore, he's a liar, and you can't believe anything Stormy Daniels said. And so I think they're thinking that one of those lawyers is going to help them on that angle. But I think the other lawyer, or maybe both lawyers, are going to look at the evidence, and they're going to throw all of throwing all of the stuff against the wall and see what sticks. They're going to actually look at the evidence and sort of piece by piece go through it. And then that sort of does help the prosecution, because they'll be focused on what they do on a daily basis, and that is look at documents. They're not trial attorneys, from what I understand, but they look at documents, they read paragraphs. And so they'll get into the nitty-gritty of all of the evidence and probably allow the jury to be led to a reasonable decision with respect to guilt or innocence. But I think Bobby is right. Criminal defense, and sometimes a hung jury is a big victory for us in some cases. And I think that's what the criminal defense attorney in this case is looking for, a hung jury. One juror that they can indicate can't reach a decision or has found that he is voted for an acquittal. That would be a hung jury.
Bobby, let me ask you your opinion about having lawyers on juries. As a prosecutor, do you tend to like or dislike having lawyers?
It depends on the case, Areva. Sometimes we want lawyers on the case because our case is, it's heavy on facts, but also heavy on the law. So if it's complicated jury instructions that are going to be read, we want jurors on there to help the jurors go through that whole process of understanding what the jury instructions mean and how it's supposed to be applied. Sometimes you don't want lawyers because if it's a very fact-specific case, the lawyers, as Mansfield's pointing out, they may be nitpicky, and as going through it, they may decide, well, the prosecution didn't make this particular part of the jury instruction, so I'm going to say that, oh, that's a reasonable doubt. And they could lead the whole jury that way in reaching that conclusion. I don't think that's the case here, because I think it's very clear that the law was violated. So I think it really comes down to, again, what they were trying to do with Michael Cohen, make him be the bad guy in all this. And I think also the specter of, do these jurors want to send Donald Trump to jail? Or the elephant in the room, do these jurors want to be the jury that may sway this year's elections? And I think that's the unspoken thing that may be out there that people may not be focusing on.
Yeah, the swaying of the election, whether, either decision, whether you decide to acquit him or to convict him, seemingly is going to have an impact on some voters. Mansfield, I asked you earlier about bringing a lawyer, and I was just refreshed. My memory was refreshed that the reason Donald Trump couldn't bring general counsel for the Trump organization or some outside lawyers, because these bills, these invoices, did not go through the normal course of business. They didn't go through the normal process that legal bills submitted for legal work goes through when you talk about the Trump organization. There was a lot of evidence of how these invoices were directed solely to Donald Trump. Checks were delivered to the White House for him to sign. So a lawyer, an in-house lawyer would have had to testify they didn't know about this. They didn't see these. They weren't handled in the normal course of business. And of course, that would have been detrimental testimony for the defense. No reason to bring that forward, because that obviously was not helpful, that this was handled outside the normal course of business. There was a lot made too about Stormy Daniels. We know the defense team argued that Stormy Daniels was just there to embarrass Donald Trump, that she really had no relevance. But I always question, Bobby, how come the defense lawyer spent so much time cross-examining Stormy Daniels? Because she definitely had very little information about the financial transaction. Now, of course, getting her, the prosecution wanted her there to show that this affair did happen, and that she was aware of this catch and kill scheme. But I just wonder whether the defense made a mistake by trying to humiliate her, trying to slut shame her, and what it actually tried to do, when from a evidentiary standpoint, she just had very little evidence that could help their case. So when we come forward, I want to talk about some of the biggest wins and some of the biggest errors that you believe each side made during the trials. It's always easy to go back, Mansfield and Bobby, and look at what lawyers did or didn't do. We do that often in cases. That's how we learn as lawyers. What are one or two of the biggest mistakes you believe in terms of the presentation of evidence during this case that the defense made, Mansfield?
I think in their opening statement, they made a big mistake of denying in opening statement that there was ever any relationship between Mr. Trump and Stormy Daniels. I mean, if there ever was a classic scenario where Stormy Daniels met the profile of the type of women that we have learned about Mr. Trump engaging with, she was the perfect profile. And when the defense says that relationship never existed, that then goes to the jury, and the jury says, do you think we don't have any common sense? Do you think that we don't understand what kinds of relationships exist between men and women? And especially when we have a record and history of the types of relationships that Trump has been accused of having and has admitted to having over the years. I think that was a big mistake, because you're basically telling the jury, don't believe your lying eyes, don't believe your lying ears, just believe what I'm telling you in this courtroom and ignore all the rest. And I just don't think that that's going to work in this case.
So you think, Mansfield, they should have stayed away from the relationship altogether and just not even mentioned it and just stayed focused on the payment?
I think what they should have done is probably the same thing that they did with Michael Cohen. Just unfortunately tried to attack her as just simply sensationalizing a story for the money. She got paid money from books and magazine and make it appear as if her story is based upon the pursuit of money. But to deny that the relationship ever happened, that's going to be a bit much. I think they had to basically try to impeach her and make her look bad, attack her character, which is what they did. But I don't think that it worked well. You recall during this trial, Stormy Daniels fared pretty well on cross-examination by the defense attorneys. She got some pretty good, quick jabs back in, and the jabs made a lot of sense. It seems as if Stormy Daniels turned out to be a sympathetic witness for the jury.
Hmm. What do you think about that, Bobby? Do you think that was a major error for the defense to tell the jurors that that relationship never happened?
They have the most difficult client in history in Donald Trump. And so Donald Trump wanted the defense to go after Stormy Daniels because that made him look good in run up to the election, but also maybe make him look a little bit better at home. So I think there's some twin things that are going on there. But, terrible client. This client wanted them to go after Stormy Daniels. And we also know that Donald Trump has a prickly nature. And so the fact that Stormy Daniels would go after him in interviews and things like that, he wanted his lawyers to go after her publicly. And that probably made him feel a lot better.
Okay, but if you were advising a client other than Donald Trump, would you take Mansfield advice and say, I'm not going to deny that relationship because we know she has too many details about the hotel room and about that night that are going to make your denial not believable?
Well, there's a whole adage, like, why would you call a sex worker a liar just because she's a sex worker? That it doesn't make any sense, right? So you just want to leave that particular person alone. She's going to get up there and say that this happened. We know that it happened. So you want to get her on the stand and get her off as quickly as possible and focus on what apparently is their main strategy, was to go after Michael Cohen. So going after Stormy Daniels just takes away from them trying to go after Michael Cohen. And it also left wide open the argument that the prosecutors were making that there's a lot more evidence here than Michael Cohen.
Right. All right, Bobby, what's the biggest error you think was made by either side?
So I think the defense made a big mistake in just ignoring David Pecker. And I think David Pecker is like a huge witness here. And if you don't address that, then basically you're admitting, the whole catch and kill scheme. And if you believe that, then you have to also believe the conversation between Pecker and Michael Cohen, which kicked the whole thing off. And so I think you had to address the David Pecker situation, and they didn't do that at all. They just called Michael Cohen a liar. But is David Pecker a liar? Is Hope Hicks a liar? Is all these other people a liar? So yeah, they definitely put all their eggs in one basket and didn't really flesh out the arguments as to why these other witnesses are not telling the truth or not factual in terms of their recitation of what happened.
Do you think, Mansfield, that the defense did enough harm to Pecker on their cross-examination where they could have stood up and said in closing that he was a liar?
No. I think that Bobby is right. There are two sort of parallel feelings that always exist in this trial with respect to Donald Trump's, the criminal defense attorneys. And it's hard to figure out what they're doing at different times. Are they talking to Mr. Trump, or are they talking to the jury? And no, I don't think that they wanted to pin down and tackle and wrestle with David Pecker, because I guess the sense is David Pecker probably testified as to what he was asked. But if he starts answering questions that he wasn't expecting, he may open up again Pandora's box, and he may actually allow the prosecutor now to ask more questions about Donald Trump and his relationship with Pecker that didn't have to be, the testimony didn't have to come in at all. And I think that's why they treated him with kid gloves, Bobby. I think they felt that Pecker knew way too much, and they just better treat him with kid gloves.
Yeah, they didn't really go after him. They went after Stormy Daniels hard. Obviously, that was for the boss. And I think you're right, Bobby. That was for the boss's wife, right? That was trying to rehabilitate his reputation to the extent that's even humanly possible. And that was also, to try to humiliate her But David Pecker, they didn't have a lot to say to him. They definitely didn't challenge him in an aggressive way in the way they did Michael Cohen or Stormy Daniels. And I think you're right, Mansfield. That was all about, he probably knows where a lot of bones are buried. He knows where a lot of dirt is. And don't get him talking, because the more he talks, probably the worse it would be for the defense team. I think we can all agree the defense team had a very difficult client. They had a very difficult case. And when you do, again, back to my storytelling analogy that I started with, they want to tell the story, or they told the story, that this is a case about a liar. And if you conclude that this man, i.e. Michael Cohen, is a liar, maybe the whole case goes up in flame. We'll see. Obviously, we'll be on trial watch for the next couple of days, as will most trial observers be. Thank you so much, Bobby Grace. Thank you so much, Mansfield Collins, for helping us make sense of this very, very important day in this Manhattan trial of our former U.S. president, who hopes to be our next U.S. president. So stay with us. We're going to continue to follow this and bring you the latest from that Manhattan courthouse. And of course, when that verdict is read, you will hear it here on KBLA Talk 5080.